Breaking news from the State House. One of the big bills in front of the Senate, the assault weapons ban.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
It also puts state laws in jeopardy that are similar to this law, which required people to show proper cause when they apply for permits.
It's a case that legal experts will be watching closely.
Another case just landed on the Supreme Court's desk, and this one has the potential to redefine gun rights in America for the next 50 years. We're talking about a challenge that could either protect millions of lawfully owned firearms or set a precedent that turns constitutional rights into political negotiation points. And based on signals coming from inside the court, something different is happening this time. Something that suggests the justices might finally be ready to answer a question they've been avoiding for years. Here's what makes this moment so critical. The Supreme Court receives around 7,000 petitions every single year, and they only agree to hear about 80 of them. That's barely 1%. So when multiple cases challenging semi-automatic rifle bans keep getting rejected year after year, it's not random. There's a deliberate strategy at play, and understanding that strategy reveals why this particular filing could break through where dozens of others have failed. The legal framework states are using to ban these rifles isn't some innovative new approach. It's actually a recycled playbook from the 1990s. Back then, the federal assault weapons ban targeted specific cosmetic features: bayonet lugs, folding stocks, pistol grips, threaded barrels. The ban lasted a decade, from 1994 to 2004, and when it finally expired, something remarkable happened. Multiple studies, including research conducted by the Department of Justice itself, found that the ban had zero measurable impact on crime rates. Before the ban took effect, the firearms it targeted were used in only about 2% of gun crimes. After 10 years of prohibition, that number hadn't changed. The ban didn't reduce violence, didn't lower crime rates, and didn't save lives. It simply made certain configurations of firearms illegal, while functionally identical alternatives remained perfectly legal. You'd think that evidence would have ended the debate, but instead, 11 states brought back nearly identical laws, just with longer lists of banned features and models. California now prohibits over 75 specific firearm models by name. New York's SAFE Act makes any semi-automatic rifle illegal if it has just one restricted feature from their list. These policies aren't built on evidence or data about what actually reduces crime. They're political theater designed to look tough on gun violence without addressing the behaviors that actually cause it. The real target isn't criminals who ignore these laws anyway. It's the estimated 24 million AR-15 style rifles legally owned by American citizens right now. Let that number sink in for a moment. 24 million. According to recent manufacturing data, there are more AR-15 pattern rifles in civilian hands in America than Ford F-150 trucks on the road. When you ban the single most commonly owned rifle in the entire country, you're not targeting criminal behavior. You're targeting your neighbors, your co-workers, the people sitting next to you at the grocery store. But here's what most people completely misunderstand about how these cases actually reach the Supreme Court and why the timing of this particular challenge might be the game changer everyone's been waiting for. The Supreme Court traditionally waits for something called a circuit split before jumping into controversial constitutional questions. A circuit split happens when multiple federal appeals courts rule differently on the same legal issue. Right now, the 2nd, 4th, and 7th Circuit Courts of Appeals have all upheld assault weapon bans in their jurisdictions. Gun rights advocates argue these decisions directly contradict the Supreme Court's own recent rulings, particularly the landmark Bruen decision that established the text, history, and tradition test. But without a circuit court explicitly striking down one of these bans and creating a conflict between circuits, there's technically no split for the Supreme Court to resolve. It's a legal catch-22 that's been trapping these cases for years. Lower courts keep upholding bans by claiming they're consistent with Supreme Court precedent, even though constitutional scholars across the political spectrum say that's logically impossible after Bruen. The Bruen test requires any firearms restriction to have a clear historical analog from America's founding era or the period immediately following the ratification of the Second Amendment. No such analog exists for banning an entire category of firearms that are in common use by millions of law-abiding citizens. The Founding Fathers never wrote that the right to keep and bear arms shall not be infringed except for muskets with bayonet lugs. Yet, appellate judges are performing legal gymnastics to avoid reaching what should be an obvious conclusion under the current constitutional framework. But here's the critical detail that changes everything. After the Supreme Court declined to hear the Snopes case, Justice Brett Kavanaugh issued a public statement. That wasn't just casual commentary. It was a signal. 4 justices need to vote to grant certiorari and hear a case. Kavanaugh's statement strongly suggests those 4 votes might finally exist. And there's something about this new filing that makes it fundamentally different from all the previous cases the court has rejected. States have engineered what legal experts are calling a brilliant trap, or a circular logic nightmare depending on your perspective. Their argument goes like this: these rifles aren't in common use for lawful purposes because we've banned them in our states, so residents can't commonly use them here, which proves they're not protected by the Second Amendment. It's circular reasoning elevated to an art form. Ban something, wait a few years, then point to your own ban as evidence that the item isn't commonly used and therefore doesn't deserve constitutional protection. Maryland actually tried this exact argument in court, claiming that because AR-15 style rifles were banned in the state, they couldn't possibly be in common use for self-defense within Maryland's borders. Meanwhile, national data shows that over 16 million modern sporting rifles were manufactured specifically for the civilian market just between 1990 and 2018. According to the National Shooting Sports Foundation, these firearms are used in less than 2% of all gun crimes based on FBI statistics. Handguns account for the vast majority of firearm-related homicides, roughly 90%. Yet no state is attempting to ban all handguns because the Supreme Court's Heller decision explicitly protects them. The logical trap gets even worse when you examine how courts are treating the military characteristics of these rifles. Some courts have ruled that military-style features make these rifles dangerous and unusual, and therefore not protected by the Second Amendment. But the Supreme Court ruled decades ago in the Miller case that weapons useful for militia service are specifically protected. The AR-15 is literally the civilian semi-automatic version of the military's M4 carbine, so which interpretation applies? Are these rifles too military in nature for civilian ownership, or not military enough to qualify for constitutional protection under the militia clause? States want to argue both positions simultaneously. They claim these rifles are weapons of war to justify bans in public discourse, then turn around and argue they're not actually military weapons when Second Amendment protection gets raised in court. What really exposes the absurdity of these bans is what happened when states actually tried to enforce them on existing owners. When New York passed the SAFE Act in 2013, the law required registration of existing assault weapons already in civilian hands. State officials estimated that roughly 1 million rifles in New York would need to be registered under the new requirements. After the registration deadline passed, only 44,000 registrations had been filed. That's a compliance rate of approximately 4%. Connecticut faced an almost identical failure. They estimated 350,000 rifles needed registration. About 50,000 were actually registered, giving them a 14% compliance rate. New Jersey's attempt at a magazine capacity ban saw estimated compliance rates under 10%. These aren't criminals ignoring the law. These are otherwise law-abiding citizens engaging in mass civil disobedience because they recognize unconstitutional overreach when they see it. Local police aren't conducting door-to-door enforcement because they understand it's functionally unenforceable. Sheriffs in multiple states have publicly announced they won't enforce these bans. Millions of gun owners simply aren't complying, and authorities can't do anything about it without triggering a constitutional crisis that would make national headlines for months. California tried a different enforcement approach with their bullet button requirements and feature bans. Within months of implementation, manufacturers created what are called featureless rifles that comply with the letter of California law while maintaining full functionality. Remove the pistol grip, install a fixed stock instead of an adjustable one, and suddenly the exact same rifle firing the exact same ammunition at the exact same rate becomes perfectly legal. Same caliber, same semi-automatic operating system, same magazine capacity in many configurations, but somehow it's no longer considered dangerous according to state law. This proves beyond any doubt that these bans are based entirely on cosmetic appearance, not actual function or lethality. While citizens find creative workarounds and millions simply ignore laws they view as unconstitutional, there's a hidden cost that's quietly destroying something fundamental about American manufacturing and innovation. American firearms manufacturers are facing an impossible choice: innovate and risk immediate criminalization, or stagnate and lose market competitiveness. When states ban firearms by listing specific model names, companies can't improve existing designs without creating legal chaos. Their engineers can't iterate on successful platforms without potentially creating a new banned variant. Here's a perfect example of the absurdity. Ruger's Mini-14 rifle is legal in most banned states, while the functionally identical AR-15 is prohibited. The only meaningful difference is that the Mini-14 has a traditional wooden stock that makes it look like a hunting rifle. Same caliber, same semi-automatic operation, same standard capacity magazines, same effective range, but one is banned and one isn't, based purely on aesthetic appearance. This isn't public safety policy. This is subjective opinion about what looks scary codified into law. The economic consequences are staggering. This regulatory uncertainty has pushed innovation and manufacturing overseas or to friendlier states. Several major firearms companies have relocated entirely. Remington's bankruptcy and restructuring saw production shift from New York to Georgia. Smith & Wesson moved their headquarters from Massachusetts to Tennessee, specifically citing the state's increasingly hostile regulatory environment. These aren't just corporate address changes. We're talking about hundreds of millions in economic impact and thousands of skilled manufacturing jobs. The firearms industry generates $28 billion in economic activity annually and supports over 160,000 jobs according to industry data. When states ban the most popular product categories, they're not just infringing constitutional rights. They're actively destroying their own state economies and driving tax revenue to competitor states. Innovation in firearms technology suffers across the board. Improvements in safety features, better ergonomics, enhanced reliability, all of it gets shelved because manufacturers fear any new feature or design element could be arbitrarily added to expanding ban lists. The result is a frozen market where companies are afraid to make their products better. Meanwhile, criminals modify firearms illegally with zero concern for feature restrictions. They're not checking compliance lists before committing crimes. But the most disturbing aspect of this entire situation isn't about firearms at all. It's about what these bans reveal regarding how constitutional rights are being treated in modern America and the precedent that creates for every other right we take for granted. If states can ban arms in common use by tens of millions of law-abiding Americans, what other rights become negotiable? Think about the implications if this logic gets applied elsewhere. States could say the First Amendment protects speech, but not if you use electronic amplification. No microphones at protests because amplified speech is dangerous and unusual. Or the Fourth Amendment protects privacy, but not if you own a smartphone. Modern technology makes you too dangerous for constitutional protection. These examples sound absurd because they are absurd, yet that's precisely the logic being applied to the Second Amendment right now in multiple federal circuits. Constitutional rights don't include an unless politicians find it inconvenient exception. The Bill of Rights exists specifically to limit government power, especially when exercising those powers would be politically popular. When courts allow these bans to stand by twisting constitutional interpretation into pretzels, they're not just undermining the Second Amendment. They're establishing precedent that all constitutional rights are negotiable based on contemporary political preferences and moral panics. That's dangerous for every single American, regardless of how you personally feel about firearms. The Supreme Court's decision on whether to finally hear one of these challenges will determine whether constitutional rights mean what they actually say, or whether they're just suggestions that states can ignore whenever it's convenient or popular to do so. 24 million AR-15 owners are waiting for an answer to that question. So are the other 330 million Americans who rely on the Constitution to protect all their freedoms, whether they realize that connection or not. The court has a choice: uphold the plain meaning of constitutional text, or allow states to continue this precedent of rights restrictions based on political trends and emotional reactions, rather than historical grounding and legal principle. That's it for today, folks. See you in the next video.